Good evening, everyone. Quick audio check before we begin the session. I hope I'm audible and visible to everybody. And even the presentation is visible. Yes. Okay. Great. Just wait for a minute to get your response, and then we shall begin. So quick audio visual check, everyone. Okay. Great. I think we can begin. Okay, so a very warm welcome, everybody. We are here today to analyze the new Jan Vishwas Amendment of Provisions Act 2023. So this is a fresh act which has been passed in the past week, right? So it's been about 10 odd days since this enactment has been passed. It was a bill which was introduced somewhere in December, and in August this year, this has now become an act, right? So we are here to discuss the provisions, how it has seen a little bit of controversy and what are different perspectives as to those controversies, right? So this is what the agenda for the day is today. So let's quickly begin with the Jan Vishwas Act. Now, to begin with, what is the government promoting this act as? The government says that this act aims at giving boost to what is known as ease of living and ease of doing business. Now, this is the basic objective that the act is aiming to achieve. Now, what do you mean by ease of living? What do you mean by ease of doing business? Now, when you look at ease of living is basically, it affects all the individuals who are living in the society, in the country as a whole, and how, because of the provisions of this act, all the people who some of the people might be getting directly affected by it. Some people might not be getting so directly affected by it. So in that case, how this act is trying to make the life of general public easier is what boost of ease of living is about. And the more important, what this act basically focuses on is your ease of doing business. Now, ease of doing business was a term which was used by the World Bank. And the World Bank had come up with this World Bank report called Report on Ease of Doing Business. Now, when you are looking at ease of doing business, what the World Bank did was they created a ranking. So in 2003 is when they started off with this report, wherein they had about certain parameters in which they decided, as per those parameters, that whether this country's regulatory framework and other legal frameworks and other frameworks, whether they are conducive and how good they are to conduct business, right? Whether it comes down to, enforcing of contracts, or whether it come down to, getting any kind of compliance related things from the government, any kind of approvals, permits from the government, how good are these countries to do business in, right? So this was a ranking system which the World Bank had created. So from 2006 till about 2020, these rankings were taken out. And in fact, to begin with, India was quite low in the ranks. Then somewhere around 2018 was when India started shooting up the ranks, right? So somewhere in 2018, from about 100, in 2018, India was about at 100 position. In 2019, we saw a jump. We came onto the 77th position. 2020, we came to the position of about being 63rd. Thereafter, from 2020 onwards, this particular ranking system was discontinued. There was a lot of controversy around this also, that how is it that you are ranking? They said that these things are politically motivated. So the World Bank, in order to avoid all controversies, in fact, stopped taking out these rankings of ease of doing business. Now, right now, there are other organizations which still do it, but so far as the World Bank is concerned, they have completely stopped taking out these rankings. But the idea still remains that how convenient are the regulatory system, how convenient is it for an entity to do business in a country, right? So keeping that in mind, this particular act here is trying to streamline things, is trying to streamline systems so that people are, it's convenient for entrepreneurs to actually come and do business in India. So it's basically trying to attract people to India. It's not just about internally, Indian domestic people, markets that we're talking about. We are actually looking at attracting a lot of FDI, right? Foreign investors to come and invest in India. And they would do that only and only if there is ease in doing business. And in fact, that is what, if you look at the World Bank reports also, a lot of stress was laid down on these reports because it kind of created an image in the global economy, in the global market, that, okay, if you rank at a decent level in this, that means this country is somewhere we can do business, right? So it was also about, having a global image, right? So this particular Jan Vishwas Act that we are talking about, this is the basic objective that they're trying to achieve, ease of doing business. Now let's come down to what exactly is this act doing, right? So when you look at this particular act, the Jan Vishwas Act, the major thing which you have to understand in this act is, this is not an act which is amending a single enactment. Rather, it is an act which is a consolidated amending act. It's an act which is rationalizing, consolidating about 42 central acts. It's going on and amending 183 provisions of these 42 central acts. So it's a consolidated act. Through one act, through one amending act, we are trying to make a change in so many enactments. So basically what they're trying to do is, instead of having 42 separate amending acts, because usually when you have an amending act, that amending act works for one particular act, right? So what it would result in 42 amending acts to be passed. Instead, what they have done, they have come up with this consolidated act, and it's known as the Jan Vishwas Act. Now, what does it aim to do? It aims to decriminalize and rationalize various offenses, right? Now, all these central acts wherein these amendments have been made, the major crux of what this entire exercise is, they have tried to decriminalize, right? So when you're talking about decriminalizing, these are the kind of offenses wherein, they're not very serious in nature, they're minor offenses. So instead of having a criminal penalty, instead of having, okay, Prince बोल रहे हैं, okay, Prince not an issue, ठीक है. तो अब यहाँ पे क्या होता है, जब हम decriminalization की बात कर रहे हैं, at that point in time, what happens is कि आप सिर्फ यहाँ पे जो minor offenses हैं, उनमें इंस्टेड ऑफ हैविंग अ क्रिमिनल कॉन्सिक्वेंस कि भाई आपको फाइन देना पड़ रहा है, या मोर इम्पोर्टेंटली आपको इम्प्रिजनमेंट होती है, वेदर इट इज 2 months imprisonment, whether it is 6 months imprisonment, but instead of doing that, we are going to change it. There might be a change which would be reflected कि आपकी punishment कम हो गई है या punishment change हो गई है, right? या punishment हटा के instead of a criminal penalty, they have completely now civil in nature. तो वो एक offense की जगह एक civil wrong आ जाएगा जहाँ पे word penalty use किया जाएगा, right? I'll just come to that penalty and fine in a minute. But the basic idea behind the Jan Vishwas Act always is that आप उसको decriminalize कर रहे हो इतनी सारी acts को, right? So that is one of the basic things. Now this decriminalization, this is not the first time this has happened, right? So it is not as though कि ये कुछ बहुत नई चीज हो रही है. In fact, very recently in the Companies Act, now there was this new Companies Act which was passed in 2013, and इससे पहले वाला जो Companies Act था वो पूरा का पूरा change किया था. So it was a new enactment which was brought about in 2013. So जो 2013 में ये act लेकर आए थे, at that time also vis-a-vis companies, there was a lot of decriminalization which was happening, which had taken place. Similarly, जब Companies Amendment Act आया 2020 में, then again there was lot of provisions जिनका decriminalization हुआ था, meaning thereby कि instead of having a criminal consequence, यहाँ पे instead आपको civil penalty कोर्ट ने गवर्नमेंट ने बोला सिविल पेनल्टी लगेगी एंड देयर विल बी नो क्रिमिनल पेनल्टी. लाइक लेट्स से फॉर एग्जांपल फॉर ए पर्टिकुलर ऑफेंस पहले पनिशमेंट होती थी 6 months along with fine of ₹10,000. तो उसकी जगह अब उसको हटा के instead of that what would be done? Something like that, okay, you just have to pay a fine, maybe the penalty, not the fine, they call it a penalty now, the penalty would be increased. कि पहले सिर्फ ₹10,000 fine था, but now penalty has been increased to 50,000, right? But consequences अब criminal नहीं रहे, consequences अब जो है वो civil nature के हो गए. That is what is known as decriminalization. ठीक? I'm hoping decriminalization as a concept is clear to everybody. ठीक है? Now let's move on to a little bit of the procedure. Kab kya hua, certain dates, not very I would say important from legal reasoning perspective, but yes, because this is something which is new, this is something which becomes very, very relevant from your GK perspective also. तो वहां पे ये dates जो है थोड़ी important आपके लिए हो जाती है, right? So when you look at this particular act, when was the bill introduced regarding the act? In Lok Sabha, it was introduced on 22nd December 22, right? So इस date को ये bill जो है यहाँ introduce हुआ था लोक सभा में. Thereafter, it was referred to the parliamentary committee. It was led by Mr. P.P. Chaudhary, and this parliamentary committee submitted the report on 17th of March 2023, right? So after that, the bill was passed in the Lok Sabha in July and in the Rajya Sabha on 2nd of August. And just about 10 days back, the bill also received the presidential assent. So on August 11, 2023, this is when it became an act, right? So this is what the change was. Now, the entire chain of event was as to how this became an act. Okay. So I hope this so far is the basic. This is clear to everybody. So let's move on further. If anybody has any questions, please feel free to use the chat box. Okay, you can use the chat box and let me know if there's any problem that you are facing. Okay, so let's continue further. Now, the next thing which is important when you just a second. Now, the next thing which has to be seen in this is that what is actually meant by decriminalization? I gave you a very general definition of or understanding of what decriminalization is. Now, let's understand under the enactment, what does it include? So it would include removal of imprisonment or fine. So there would be certain provisions in which there is both, imprisonment as well as fine is given. So there might be a proposal wherein both are removed. So there is no offense as such, that offense itself has been removed, or it could be that either of them have been removed. So only imprisonment remains or only fine remains. That's one. Next is removal of imprisonment. In some cases, there is imprisonment as well as fine. So imprisonment has been removed, but fine as a consequence still remains. Next is when you talk about it, is when you talk of enhancement of fines. Now, there might be certain provisions wherein imprisonment might be removed completely, but fine is there, and fine in fact has been increased, right? So there could be a scenario wherein the fine is increased. Next is when you talk of conversion of imprisonment and fine to penalty. Now, in this, what it means is that instead of it being a crime, now, when we think of something as an offense, as a crime, as a criminal offense, then the punishment which you get is either imprisonment or fine. So when you are changing the punishment from imprisonment and fine to penalty, in effect, what you are doing is you are turning the criminal offense into a civil wrong, right? So now it is no more going to be considered as a criminal offense, rather it is going to be a civil wrong, right? So this is what I was referring to initially. In the last slide when we were discussing decriminalization, I was telling you there's a difference between fine and penalty. So this is the fine difference between fine and penalty. Fine and imprisonment is something when we are talking of a crime, the relief which you get as a crime, whereas penalty is something which you get as because it is a civil wrong, right? So here it could be a scenario that instead of imprisonment and fine, there is a complete only penalty. And a lot of times if you read the act, these penalties has been kept to be pretty high. So fine might have been of only 2,000 rupees, but the penalty could actually be to the tune of 10 lakh rupees. So because end of the day, what you are removing, which is most important, is the imprisonment aspect. You are improving, you are kind of removing the aspect which relates to ensuring that the person's life and liberty is getting curtailed. So that's the basic idea, because end of the day, when you are talking of decriminalization, why is it so essential? It is essential because, if you are working, if you are conducting a business under the fear that, oh, for this particular minor mistake also, I might go to jail. Now, you don't want people to work under that fear. That is why this process of decriminalization has come into place, right? So here what they're saying is that instead of imprisonment, yes, there might be monetary consequences, but life and liberty are not getting affected. That is why now it becomes a civil wrong. Now, next thing which you have to see is introduction of compounding. Now, what is compounding of offenses? When you look at the concept of compounding of offenses, can anybody tell me what is the concept of compounding? I would like to know if anybody can help me out. What do you understand by compounding of offenses? It's a term which is used in criminal law. It's a process which is provided under the CRPC. CRPC is your Criminal Procedure Code. CRPC provides for the concept of compounding of offenses. So can anybody help me out? What exactly do we mean by the term compounding of offenses? I know there is a slight lag between where I am and where you might be. So I'll give you guys a minute. What do you mean by compounding? Yes, I think I'll give you a minute. Because compounding is something, not only in this perspective, but compounding is a concept which has been seen, something which is important from your legal reasoning perspective. You do get passages on procedural law which deals with compounding, right? Okay, Tirtha is telling me it is an agreement. Agreement to do what? Agreement in case of a criminal wrong, wherein we say that the crime or the particular offense for which you are being charged, can there be a settlement, right? So agreement here, right, when you're talking about a settlement between the parties, that is, you're saying that even though I filed a case, now I don't want to go ahead with it. So you are saying that there can be a compromise, a settlement, an agreement which can be reached between the parties, and the offense, the trial of the offense would not take place here and forward, right? So there's a compromise which is arrived at. Usually in criminal cases, because I'm sure all of you remember when you talk of a crime is supposed to be against the society at large. So when you're looking at that from that perspective, criminal wrongs are generally not you are not allowed to settle them. There is no settlement or there is no compounding. But for certain offenses, if the law specifically provides, then there can be a settlement, right? So that is what is compounding of offenses. So Act here allows for a lot of offenses to be compounded, right? So not only is it saying that is it turning offenses into non-offenses or offenses into civil wrongs, but it is also providing for compounding of offenses. If it's not too serious in nature, then the parties, if they agree, then they can go ahead and reach a compromise and the matter comes to an end, right? So that is what is compounding, right? Yes, Himanshu, you are right. Settle out of court, smaller offenses. Yes, both of parties are called and they go ahead and go in for a settlement, right? Okay, chalo. So this is basically the different ways which the Act uses to decriminalize, right? Now let's move forward. Next, what you have here is what are the implementation mechanisms, right? So what is it that the Act is using? So the first and the most important thing here is the Act proposes a measure for effective implementation. How? What they have done is they have tried to revise the fines and penalties. In what way? To be commensurate. That means कि आपको आपको यहाँ पे चेक करना है कि कितना सीरियस आपका ऑफेंस था। जितना सीरियस आपका ऑफेंस था उसी के हिसाब से, उसी के कंपैरिजन में विल बी योर पनिशमेंट, राइट? सो योर punishment and your seriousness of the offense have to be taken into account, right? So this is something what is, when we started off with the Jan Vishwas, I said there, this act goes about rationalization and decriminalization, right? So the first point here is about rationalization, right? So you're trying to rationalize it. By rationalizing, you are trying to say that whatever, how serious is the offense is going to decide how much punishment you are should be getting for it, right? So there is sort of a a complete overview which has been done कि कितना punishment किसके लिए देना चाहिए. Next is this concept of establishment of adjudicating officers. Now, this is something which has been, criticized a lot, or this is something which has been in news. This is one of the main reasons why this law has been in news. Now, what do you understand by this? Now, normally, if it is a crime, then let's say if there is any kind of penal consequence which is attached to a particular activity, like let's say in the Companies Act, or in the like when you're talking about the Jan Vishwas bill, there's a lot about the Environment Acts. You have the EPA, the Environment Protection Act, you have the Air Act. There have been amendments made to those acts specifically, wherein a lot of criminal offenses have been now turned into civil offenses, right? So what has happened there is you have adjudicating officers instead of going to the court. So instead of going to the court, you actually go to the adjudicating officer to get your disputes resolved. So here, if you look at the act, what are they doing? They are rationalizing, decriminalizing. And how are they decriminalizing? They are introducing the concept of adjudicating officers. Now here, what are they doing? In effect, they are ensuring that the burden of the court is reduced. That is another, one of the things which has been said by the government, that why is it that we are doing this? Why are we introducing adjudicating officers? Why are we establishing appellate authorities? There are certain laws under which they have introduced adjudicating officers, and they've also introduced appellate authorities. So instead of going to the court which are already overburdened, rather, the matter will be settled by an authority which has specially been created for this purpose, right? So therefore, this is another way in which they are trying to decriminalize, or they are trying to rationalize the system, right? So we'll discuss adjudicating officers and appellate authorities in a little more detail a little later. But generally, these are the three main things. And this is for a very novel sort of a concept which is there under this act, which says there is a periodic increase in the quantum of fine and penalties. Now, usually you must have seen, when you, especially fine and all, you see a lot of it when you're reading the IPC. Right? IPC is your Indian Penal Code. So under the Indian Penal Code, you must have seen there's an X amount of fine which is there for a particular offense. Now, when you look at D is saying that not only will the fine be there, but there is going to be a periodic increase. So in fact, section 3 of this particular act specifically talks about it. What does it say? It says the fines and penalties provided under various provisions in enactment shall be increased by 10% of the minimum amount of fine after the expiry of every 3 years from the date of commencement of this act. That means if today the fine given under the particular provision, minimum fine, let's say is 10,000 rupees, then by 10%, there is going to be an increase, right? So there would be 100 rupees increase every 3 years to this fine also. So, in a way, this is something which is a very practical approach to it. That otherwise, sometimes it happens that, 10 years, 15 years down the line, the fine which is provided under the enactment might feel like peanuts. Right? So you don't want that the penalty or the fine which is provided in the act should become obsolete, because obsolete हो जाएगा, उसका कोई purpose ही serve नहीं होगा अगर वो उसमें periodic increase नहीं होता है, right? So this is something which is like a novel sort of a concept which is being brought about under this particular enactment, right? So you have a periodic increase. Take. Chalo. Now these are your implementation methods. Now let's move on further. Now, these are the benefits of the act which the government itself has provided. Right. So this is where we are looking at it from the government's perspective. What are the various benefits of the Jan Vishwas Act? Now, this I have picked up specifically from the government website, the government website where they have introduced the Jan Vishwas Act. This is what they have said. Now, the first point which the government is trying to make here, it says it will contribute to rationalizing criminal provisions, which we just discussed. So you're trying to make them, kind of as per the seriousness of the offense. And it says ensuring that citizens, businesses, and government departments operate without fear of imprisonment for minor technical or procedural defaults. Now, this is basically, one of the main aims of this entire enactment, that for a minor technical procedural error, you should not be going to prison. You should not be afraid that, as tiny as I might actually end up in prison, right? So that is one. Next, it says is the nature of the penal consequence should be commensurate to the seriousness. This is something exactly what we just discussed. There has to be a balance. Hi guys, little hitch in the internet. Okay, so we were on the second point, which talks about the nature of or consequence that has to be commensurate, right? So there has to be a balance between how serious the offense is and how serious, how much of penalty should be given, right? So that between both the things, there has to be a balance which needs to be maintained, right? Now, let's move on to the next. Next important point which the government gave in here was that they said that, just because of these minor little technical or defaults which somebody might have done, it should not be that you come to a criminal court and already the criminal court is overburdened, right? So you are, in fact, because of these minor offenses, you are clogging the justice delivery system, in the sense that you already, the system is overburdened, and instead of reducing the burden, you are putting pressure on an overburdened system. So in a way, it is easy for doing business, but this is another angle wherein you are making it easy for people living in the society also. So ease of living, when you look at the ease of living as the objective, this is something which also comes within the concept of ease of living. That if there is less pressure in the criminal justice system, the criminal justice system would be able to provide a better and a faster remedy, right? So that is something which is another benefit or another thing that the government is trying to achieve. Next, it says is decriminalizations of provisions affect citizens and certain categories of government. Now, again, the same thing, fear of living, fear of imprisonment for minor violations would not be there. And the last thing which the government has specifically mentioned here is that it is a consolidated amendment, meaning thereby we say that since, instead of having all these separate, this is sort of a landmark law wherein we are rationalizing laws as a whole. So there are 42 acts which are being rationalized together, right? So instead of doing it individually, as a block, as a whole, it is doing. And that is why this is supposed to be sort of a landmark, sort of an amendment, and not just one run-of-the-mill amendment, right? So that these are the reasons or the benefits which the government has given of the Jan Vishwas Act. Now let's try to rationalize it a little at our end. We have heard about what the government is saying and all. Now let's move on and understand as to how is it actually affecting, or what are the repercussions, or how do you actually go ahead and interpret it. Now, even though, the government here again and again has laid a lot of stress on decriminalization, but one thing which the government has not really focused on is that there is a shift of power which is happening when you are doing decriminalization. Now, what is this shift of power? Now, most of the offenses where decriminalization is happening, what is happening herein is that the from being a crime, you are now turning into a civil offense. If it were a crime, then the case would go to a criminal court, right? So generally it would go to a metropolitan magistrate, or it would go to, a judicial magistrate, right? So either of the two criminal cases is where the case would go if there are any kind of criminal offenses. But instead of that, what you're doing is now you are turning them into civil offense. And by turning them into civil offense, in effect, this power to adjudicate, this power to decide whether a particular wrong or violation of an act has been committed or not, you are shifting the power from the courts onto civil authorities. And what one would realize when one actually reads, आप अच्छे से अगर ध्यान से इस एक्ट को पढ़ोगे तो आप क्या realize करोगे कि ये जो जितनी भी shifting है from crime to civil, they have created what are known as your adjudicating officers. So lot of acts, they have created adjudicating officers, and these adjudicating officers are what? They are bureaucrats, right? In some acts, आपने यहाँ पे joint secretary level के लोगों को रखा है. In some acts, you have kept the district magistrates. Again, you are looking at keeping executive, you are looking at keeping bureaucrats, and आपने उनको दी है यहाँ पे decide करने की, almost like very close to judicial authority. So this is one of the criticisms which has come of this particular act, that आपने courts से power take away करके, you're giving this power to the executive, right? So which, there are some people who are not very happy with, because what they're saying is, end of the day, what this leading to is, it is just the executive which is getting all the power. That is the government itself which is getting all the powers, right? So like when you're looking at, I'll give you some examples of this, like when you're looking at the Environment Acts. Now, under the Environment Acts, what was the system? The system was, there was certain criminal, certain wrongs for which there was criminal imprisonment as a punishment. Now, what did they do? They changed this. They changed this and turned it into only monetary penalties, which means from a crime, now it has become a civil wrong, because it is only monetary penalties. Now, these penalties might be very high, up to 15 lakhs, right? But initially, the punishment, there was a imprisonment plus about 10,000 is fine. But that has been changed, and now it has only become a penalty. So when it was a crime, at that time, you would go to the court. You had to go to the metropolitan magistrate. But now, when it is only a penalty, then you go to an adjudicating officer who is at the joint secretary level. So in effect, you are taking out the courts from this, and you are giving it to the power to the joint secretaries, power to the just the executive, right? So this is one, one perspective of this problem. Like another example of this is when you look at the Indian Forest Act. Now, under the Indian Forest Act, they said that the forest officer, again, part of the executive, the forest officer can conduct inquiries on damage done to the forest. So if he wants, he's the one who has the power to conduct this inquiry, and not only this inquiry, but he can order compensation for damage, and there is no upper limit for this. So there is a complete discretion which is given to the forest officers that, they can put an X amount of compensation, right? So this again is, the executive getting the power to decide penalties, right? Which is in certain, with certain opinions, in certain, like I would say that these are different perspectives, right? So one perspective is, by giving so much of authority to the executive, you're actually creating an imbalance with the entire concept of separation of power, because, so far as our constitution is concerned, we are supposed to have separation of power, right? So when you're talking about adjudication, that is something which should be done by the judiciary. And when it comes down to implementation, that is something which is supposed to be done by the executive, right? So there is this thing which is amiss here, right? So like I was giving you the example of the this Air Act and the EPA. Now, there is another angle to this EPA and the Air Act where criticism has come into play. Now, when you look at the Air Act and the Environment Protection Act, in these two acts, earlier the system was that if there is a complaint filed by the authorities, so, the authorities like in the Air Act are the air pollution control boards. So if the air pollution control boards feel that, this person has violated the Air Act, filed, right? So for any kind of violation wherein a criminal consequence is there, you want to file a criminal case, it could be filed either if the specified authority asks for it, or it says by any person who has given notice to the authorities. So even if you are an individual, right? So you give notice to the authorities and thereafter you could file a case in the criminal court. But now with the change in by this new enactment, what has happened is only the adjudicating officer has the authority to conduct an inquiry. And after conducting the inquiry, he can impose penalty, right? So here, basically, this entire concept wherein any private person could also go and approach, that is something which is missing. So in a way, there is a lot of, power which has been given to this adjudicating authority wherein he will decide that, okay, whether inquiry should be conducted or not, he conducts the inquiry and then will have the discretion to decide whether he wants to impose penalty or not, right? So therefore, this is something which has again come under the scanner, that this is something which is not very, very fair, criticism of this particular act, right? Now, certain points so far as adjudication is concerned, which we just discussed, we'll just quickly go through them. The first is talking about the independence of adjudicating officers. Now, here again, end of the day, when you are looking at a court deciding the matter, when a court is deciding the matter, there is a lot of independence of judiciary. So there is this fear amongst people that since it is the adjudicating officers who are nothing but people appointed by the government, they might not be very independent, when they're giving their decisions. When it comes down to conducting inquiries or comes down to giving their decisions, there might not be a lot of freedom there. Next thing it says is judicial and technical competence. Now, these adjudicating officers, especially under the EP, the Environment Act and the Air Act, these are supposed to be joint secretary level people from the government, right? Now, these are not people who actually have specific knowledge, neither do they have judicial knowledge, nor do they have technical knowledge so far as the Air Act is concerned, right? Like when you look at the Air Act, under the previous system, they said it is the state board who would decide whether a case needs to be filed or not. And when you're looking at the, what the state board comprises of, who are part of the state boards, then you have people who have technical knowledge who are part of the state board. So that technical knowledge, that technical competence would be missing when it comes down to adjudicating officers, right? So this is another, a critique of this particular provision. Then, so similar is significant technical input is needed, even when it comes down to legal proceedings, that will be missing. And like we just mentioned about separation of powers, right? So therefore, it's the executive which is doing both. It's seeing whether the implementation happens, and it is also deciding whether punishment should be given or not, right? So both these angles are being undertaken by the separation of, by the executive only. Okay. Now, always remember, there are always two sides to a coin. So one side is what we just discussed. So this is like the sheer criticism that, all this concept of adjudicating officers and taking away criminal provisions is not something which is good, right? But then there is another angle to it. Now, when you look at the criminal system in our country, when you look at the system, there is this entire rise in criminal cases. So there's this entire data which I have here that, there is a growing concern about the number of criminal cases we have, the amount of pending criminal cases that we have in our country, right? So, and then there's always this entire concept of when you're looking at why do we need this act? So we need this act, because to punish people as a crime, or for small things, to just give penal consequences, to give consequences which will actually affect the life and liberty of the people, is too extreme. And at times governments use it just to, the government not just use it, the governments, they misuse it also. Right. So a lot of times, because there is over criminalization, the other aspect is that instead of having, for small things, criminal offenses, you rather have penalties, right? And when you're looking at penalties, it will have to be certain bodies which are separate, distinct from the judiciary, which are going to be carrying out this entire adjudication process. And this is not something new. When you look at the taxation matters also, there also, it is not the courts who are going to be doing who do the adjudication. They are the executive itself who are involved in the entire process of adjudication. So on the same lines, if under this Jan Vishwas Act, if they are creating these adjudicating officers to decide the disputes, it is not a very different or a very, an approach which should be criticized too much. That's another angle to this entire argument, right? So always remember, in your legal reasoning paper, there would always be different angles from which a particular law is shown to you, right? So always remember, when you're answering in any legal reasoning question, you always answer the question from the perspective of the author, right? So if the author is, a huge critic, is completely not in favor of the Jan Vishwas bill, then he would go in for the argument that we were giving earlier. But somebody who really feels that, okay, Jan Vishwas bill is not that bad, because at the end of the day, we do have a lot of pendency in the criminal cases. We need to streamline it. It is not something which is which has never been done before. So this is this manner of streamlining is something which is usual. In fact, when you have this entire concept of tribunals, of quasi-judicial forums, what are they? That is also, in a way, you're taking away burden from your regular legal system and you're giving it to a different forum. Right. So similarly here, when you are creating an adjudicating authority, that adjudicating authority is going to help you in getting the processes streamlined. There would be ease of doing business, as they call it, because then people are not going to be scared that, okay, for a small technical thing, I would be going to jail. Right. And also it would lead to the prisons and the you have the problem of overcrowding of prisons. You have the problem of the judiciary being overworked and too many pending cases. All those also get resolved, right? So that's another opposite, a different perspective to the argument which is being just given to you, right? So this is something which is in favor of the Jan Vishwas bill, right? So let's move forward. Now, another thing which has been in news regarding the Jan Vishwas bill is your Drug and Cosmetics Act. In fact, if you, when this entire bill was tabled before the Lok Sabha, then one of the first oppositions which came for this bill was regarding the Drug and Cosmetics Act. Now, couple of changes were made to this act. One or two changes were where instead of imprisonment and fine, they had completely changed into a penal consequence. So, the penalty was pretty high there. So to the tune of 10 lakhs, 15 lakhs, the penalty has been increased. So that is not something which was in controversy. That's perfectly fine. But the one thing which turned out to be controversial was that when it came down to this concept of when it came down to this concept of standard quality or not of standard quality. So what is this provision 27, which actually allowed for compounding of offenses, an offense which is done by a drug manufacturer. Now, what this particular amendment did was, they said that 27D, all the offenses which come under 27D, they would become compoundable offenses. Now, the criticism was that by allowing, compounding of offenses, in such a case, it would mean that manufacturers would be selling substandard drugs get away lightly. They would not be liable for selling substandard drugs. Right, so this is something should not be done. This is against. So this would be. They even went ahead to say that this is lethal and would lead to an antibiotic resistance because you are selling drugs which are substandard. Right, but then when you actually delve deep into the problem and you see what exactly 27D is about. Now, 27D, if you look at the Drug and Cosmetics Act, what it says is it covers minor offenses. Why? Because all the provisions preceding D, your A, 27A, 27B, 27C, that is what talks about drugs which are adulterated, drugs which are spurious, and drugs which are manufactured without license. So if it is a drug which is adulterated, spurious, or manufactured without license, then the punishment there is still criminal in nature. Right, so there the punishment is not even, they haven't even decriminalized it. Right, so you could there could be imprisonment for it, and there could be a heavy fine for it. But when it came down to 27D, 27D covers only minor offenses. Right, so when you look at the act has certain rules which were made somewhere in 2008, and those 2008 rules, they told you that what would be covered under these minor offenses. So minor variations, like if a tablet is chipped, it is improper, or it is unevenly coated. So things like that would come under these minor offenses. So what this act is trying to do is, this is where compounding is allowed. But why did all this blow up? Because right when, this entire Jan Vishwas bill was being, incident which happened. In Gambia, there were about 70 odd children who died because of a cough syrup which was manufactured in India. So there's an Indian manufacturer who had sold this cough syrup to Gambia, had exported this cough syrup to Gambia, and wherein 70 children were died. And some about 20-30 parents of these Gambian children who had died had actually initiated a litigation against this Indian pharmaceutical company. So all this happened right at this time. So in a way, what the government or what the critics said, that when you are trying to say that there can be compounding of not of standard quality drugs, then what kind of image are you creating? People would think that on one hand, the Indian pharmaceutical companies are selling substandard drugs, and on the other hand, the government is going ahead and making it a compoundable offense. Right, so but not realizing that what are the nitty-gritties of it. Right, so this is something which you keep in mind. As a law school student, you just don't go by what is there in the media. You actually go ahead and read the fine print. Right, is it really happening the way it is being shown in the media or not? Right, so there are always different facets to the same problem. Right, so but this is one controversy because of which the Jan Vishwas bill has been in news. Okay, chalo, I hope this is clear. Let's move forward. Now, the next thing is another thing which has been an issue, or why this bill has been criticized, is the changes which have been made to the Indian Post Office Act. Now, what they have done is, whatever offenses were there in the Indian Post Office Act, they have omitted all the offenses under the Act, right? So, under the Indian Post Office Act, nobody can be held liable for a criminal offense. Now, it's perfectly fine if they felt that there was a need, but it raises two major questions. First, it was said that since under the Act, the only people who committed the offense were post officials. So then how is it relevant to the objective of the Act? What is the objective of the Act? The main objective of the Act is ease of doing business. Right, ease of living and ease of doing business. So how is it that you are actually, by completely omitting all the offenses under the Indian Post Office Act, wherein only the people, officials of the post office are getting affected by it, how are you achieving either of these two objectives? Right, so this is something which is being questioned. And another thing which is, I feel, more pertinent is when you look at that even offenses which include unlawful opening of postal articles. Now, even this has been removed from being an offense. Now, here it straight away affects your right to privacy, which has been held to be a fundamental right. So if I am sending something, a postal article by post, anybody can open it and there would be no penal consequence for the same, right? So this is something which has been criticized a lot, that it straight away leads to invasion of privacy if this is not going to be considered as an offense, right? So that is the take on the Indian Post Office Act, so far as Jan Vishwas is concerned. Now, this, I think, is where we will look, where we come to an end with vis-a-vis specific acts, which have been in news and which are really, really important from the perspective of the Jan Vishwas bill. Now, we'll just look at an overview because, there is criticism of this act. And some of the criticisms we've just dealt with, and a couple of things which are left are, this entire doing of business thing. Now, there's this Observer Research Foundation report, which is titled as Jailed for Doing Business. Now, what does this jailed for doing business report said? This report said that there are 26,134 imprisonment clauses in 843 economic regulations so far as India is concerned, right? So here people are saying this one, you can say type of critique is that there's so many laws in which decriminalization needs to be done. So what this law is doing is just a drop in the ocean. It's barely doing anything, right? It needs to have done much more. So the amount of what was expected from the act is much more, and what the act has delivered is very, very less, right? So it is like the opposite kind of a criticism from saying that you're doing too much, you are just decriminalizing and putting adjudicating authorities. Here it is saying that you're doing too less, right? So that's another perspective. And then it says that the regulatory offenses to be decriminalized need to be prioritized, right? Not from the view of ease of doing business, but also from the criminal justice system. So what they're saying is that, okay, you're looking at decriminalization, but this decriminalization should not be just from the perspective that doing business is good, is become easier, but rather it should be that the entire criminal justice system should be, there should be overhauling, that the entire criminal justice system should benefit from it, and not just, the purpose should not be ease of doing business. The purpose should be to make the criminal justice system a little better, a little more effective, a little more efficient, right? So therefore, the objective that you're trying to achieve here is very limited. So basic idea here is it is a very limited sort of an objective. So, this is a criticism, though some might agree, some might not, because end of the day, when you are trying to achieve something, it is not possible to achieve everything by a single enactment, right? So to say that this is only doing ease of business might not be a very good argument, right? And the last, it says, the act confirms the understanding of the government that decriminalization should be regulated to regulatory norms only. Now, this again is a criticism, because it says that this decriminalization, as per the government, it should only be related to a regulatory domain. So here, when you look at the acts in which decriminalization has happened, they are basically acts which are talking about business, acts which are talking about regulation of how activities should be done. So this, this decriminalization needs to have a broader perspective and not just to regulatory domains, right? So therefore, that's another criticism of this particular enactment. I think that is where we come to an end so far as this Jan Vishwas Act is concerned. I'm hoping that the concept of what basically the idea behind this act is clear to everybody. And now from here and forward, if you do get a passage on the Jan Vishwas Act, this would be something which would not be too difficult for you. The entire purpose behind conducting these workshops or these webinars is so that you get accustomed to these concepts. Here the idea is not to make you familiar with these concepts from the perspective of your GK. GK is fine, that's one angle to it, but it's more important that if such a phenomena comes in your legal passage, in your legal reasoning section, you should be able to comprehend it and solve the questions easily, right? So therefore, there was a lot of different perspectives which were dealt with in today's session. So I hope you're able to appreciate all of them. Okay. Chalo then, take care everybody, and bye-bye, study hard. And if you still, if you feel that koi problem ho rahi hai, you're not able to, understand any of the concepts which was told to you, please feel free to use the comment section, leave a comment, and I would get back to the same. Okay, chalo then. Take care, everybody. Best of luck. And as always, we are Clat possible. So if you have any kind of problem, any query, any help vis-a-vis your Clat preparation, please feel free to contact us. These are our various social media handles. Okay. Okay. Thank you, everybody. Bye-bye. Have a good evening.